Okay, we are back to streaming live on YouTube. I'm calling. Oh, I'm sorry, the defendant's not here yet. Give me just a second. Okay. All right. So I'm calling State of Georgia versus Trayvon Booker. So there at the jail, if you're Trayvon or Trevin Booker, just wave at me to confirm that. All right. Thank you, sir. Mr. Booker is charged with possession of marijuana with intent to distribute, warrant 2025 WA 73185, and possession of marijuana more than 1 ounce. That's warrant 186. Representing the state is Ms. Thomas. Representing Mr. Booker is Mr. Rogers. And Ms. Thomas, you can call your witness.
Yes, Your Honor. Officer Jackson, could you please raise your right hand? Do you solemnly swear and affirm that the evidence you shall give before the court today shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Put your hand down, state your name for the record.
Officer Ryan Jackson,
How are you employed?
Clayton County Police Department on the Criminal Apprehension and Gang Enforcement Unit.
Were you so employed on or about March the 6th of 2025?
Yes, ma'am, I was.
You who?
I was.
Okay. And would you happen to have investigated an incident at the location of Lake Harbin Road at Mount Zion Boulevard?
Yes, ma'am, I did.
Is that within the city of Rex, Clayton County?
Yes, ma'am, it is.
And did this incident involve a Trayvon Booker?
Yes, ma'am, it did.
And what happened?
I conducted a traffic stop on a vehicle for failure to maintain lane on Mount Zion Boulevard. I couldn't activate my emergency lights and sirens, conducted a traffic stop on that vehicle. I made contact with the driver and advised him of the traffic violation. I asked the driver to step out of the vehicle, detained him, and also the passengers. I had them step out of the vehicle as well.
Okay, let me stop you right here right quick.
Mm-hmm.
Which one was the defendant, driver or passenger?
The defendant was the front seat passenger.
And there were other passengers in the vehicle?
There was one other passenger and a driver.
3 people total in the car?
Yes, ma'am.
Okay, now please continue.
Yes, ma'am. So after I had everyone step out of the vehicle, I began writing my traffic citation. At that time, Officer Clark arrived on scene with his K9 partner while I was writing my traffic citation, conducted a free air sniff around the vehicle, to which his dog positively alerted on the vehicle, which prompted me to conduct a probable cause search on that vehicle. During that search, I located a backpack in the back seat of the vehicle and located 3 individual plastic bags with a green leafy material believed to be marijuana inside of a clear container. I placed everyone into handcuffs. I have asked everyone of their Miranda rights separately, and asked everybody about the marijuana. Nobody took ownership of the marijuana.
And you said this backpack was in the back of the car?
Yes, ma'am. And it had a total weight of 31 grams, which is over 1 ounce, which is a felony.
Now, what connects this defendant to that backpack?
It was within arm's reach of the defendant.
And he's the front seat passenger?
Yes, ma'am.
Did he make any statements to you as to what was going on in the car? Let me backtrack. Did he make any statements to you?
No, ma'am.
Okay. Did any other persons in the car make a statement to you regarding that backpack?
No, ma'am.
What happened to the contents, to the backpack and its contents after?
All of it was taken to Clayton County evidence and placed in an evidence locker, and a DOFIS form was completed so it can be sent off for testing by the GBI.
Was there anything inside of the backpack that could lead you all to know who the owner of it was?
No, ma'am, there was no identification cards or no any type of identifiers inside the backpack.
What was inside the backpack other than marijuana?
That was it.
And when you say 31 grams of marijuana, how much marijuana are we talking about, size-wise?
It'll be equivalent to just 1 ounce of marijuana, probably like a handful.
So in a baggie, a Ziploc.
It was in
Right.
3 different
Elephant
blocks. Yes,
Hmm?
ma'am. Yes, ma'am.
Okay. And there's nothing else in that backpack.
No, ma'am.
Okay. Yeah, that's all I have. Oh, no, one more question. I'm sorry. The person that you encountered that evening, do you see them in court today?
Yes, ma'am, I do.
Can you identify them by physical appearance or article of clothing?
It's gonna be a black male wearing a orange shirt.
Okay. Yeah, that's all I have. Reserved right for redirect.
All right, Mr. Rogers.
No questions, Judge. Just argument.
All right, and Ms. Thomas, any further witnesses from the state?
Not at this time, Your Honor.
All right, and no witnesses, Mr. Rogers.
No, sir.
All right, so Ms. Thomas, do you want to reserve closing?
I do, Your Honor.
All right, Mr. Rogers.
Well, thank you, Judge. I'd like to point out, number one, there's no lawful presumption that attaches to Mr. Booker under the circumstances. He's not the driver. There's no testimony that he's the owner of the vehicle. So at this point, they don't have, any one of those presumptions to rely on. The officer stated his reason plain and simple, mere proximity. That's not the exact words he used, but that's what he was saying. Is the mere proximity. That was the connection that was in arm's reach. But mind you, Mr. Booker is a front seat passenger. There's a back seat passenger and there's a driver in this vehicle. So I point all that out to say that, Judge, I think you kind of know where I'm going with this. Number one, well, let me back up. The only basis alleged for the search was the canine alert. That's not the officer saying he smelled anything that led to the search, or anything of that nature. So that's not even what's being testified to. At last check, Mr. Booker is not a canine. So the fact that a canine, which, without getting into all the suspect elements related to canine searches in general, there's no evidence that Mr. Booker is a canine, so he can't be held to that standard. And again, it is well established that a finding of constructive possession must be based upon some connection between the defendant and the contraband other than mere spatial proximity. That's O'Neal v. State, 285, Georgia 125. I've
Can you give me that citation one more time?
even entertained idea. Yes, sir. It's O'Neal v. State, 285, Georgia 125. There's plenty of other cases I could go on for a minute though, but another relevant case is Collins v. State. This one is a 2021 Georgia Supreme Court case. If you want some, this it might make it a little more efficient for the court.
Sure.
312 Georgia 727. And what Collins v. State notes is that mere presence or approval of a criminal act is not sufficient to render one a party to the crime. In a sense, so what we have here is there's no basis to allege that he's in possession by his control of the vehicle. He's not in actual possession. And I say that to say that even if, which isn't offered, but I'm just entertaining contingencies, even if he was aware of the marijuana, which we're not agreeing, that still wouldn't be enough in and of itself to say that he was a participant in the possession of it. Because what I like to point out is that when the court says that mere presence, what's implicit in the fact that approval is not sufficient is knowledge, because you can't approve of something that you don't know about. So even knowledge with approval is not enough. So for all those reasons, just the fact that the officer didn't testify to any smell of marijuana, no basis to say that Mr. Booker is a canine, that the car smelled of marijuana, that he controlled the vehicle. All they have is mere proximity, Judge, and that's insufficient to charge him. But that's, that is beyond the bounds of even common sense. Again, if I stand next to a Rolls Royce, Judge, that does not put me in possession of the Rolls Royce just because it's in arm's reach. I wish it worked like that, because I'd probably be driving a Rolls Royce if it was to put me in possession just to stand near it. But that's not how it works, Judge. So for all those reasons, I would ask that the charge be dismissed, both charges be.
All right. Thank you, Ms. Thomas.
I stand on the testimony of the officer, Your Honor.
All right. I'm going to take 1 second and just review. I want to review this Collins v. State case real quick. I will be back and it'll only take me a minute or two here. I'll be right back.
Your Honor.
Okay, I'm back. Okay. So I did review. I was looking for there was some specific language I remember reading last time we were talking about a similar issue here, and I couldn't find it. I looked back at the O'Neill case too, but certainly in O'Neill, explicitly the Supreme Court of Georgia said that a finding of constructive possession must be based upon some connection between the defendant and the contraband other than mere spatial proximity. And I think that spatial proximity is really all that there is here in terms of pointing to this defendant and the backpack that was located beside another person in the back seat and in a car that someone else was driving. So I do not find probable cause today on the charges. I am going to dismiss these charges and I will issue that order today. And so, Officer Jackson, if you don't have any other cases, you can be excused. Thank you.
You guys want to get a breakout room with him?
Yeah.
Thank you.
Okay. Let's see. You can go into breakout room number 2.